So let me start by sharing my slides. Here I've used the term internal and external, and those of you who follow the case law of the Court of Justice, this divide might remind them of the internal and external limitations which Advocate General Spooner referred to, for example, in his opinion in Funke Medien. They are used this expression to outline the room left for national legislatures to open up the system of exceptions and limitations. And he pointed out that the EU Charter of Fundamental Rights is an external limitation to copyright. There is a flat interplay between copyright and other fundamental rights, but when it comes to setting the balance, this is a job that has been done by the EU legislator, and therefore member states cannot break this internal balancing mechanism that has been established at the EU level. Here, I would like to use these internal, external interfaces slightly different, and I would like in particular to discuss with you the following points. The first one is indeed trying to understand which legislation does apply. And I would say that in this sense, Article 17 of the DSM Directive is an excellent, although very complex, case study. First, because it raises the question when Article 17 itself does apply. And in this respect, we shall see that, for example, the very notion of online content sharing service provider might not be necessarily straightforward for certain services. And the second is indeed the relationship between Article 17 and, for example, the Digital Services Act, in order to understand when either instrument does apply. The second level of complexity that I would like to touch upon relates to the very object we are speaking of, because as if things were not already complex enough, there might be different scope of protection depending on the object at hand. And I will exemplify that by reference to works of applied art, for which now a new referral to the Court of Justice has been made just a few weeks ago, and also with regard to the scope of right holders control. Then I would like to outline what difference it makes to speak of one right instead of another. And Emmanuel, in her presentation, noted the national transpositions, for example, of Article 15 of the DSM Directive, the press publisher's right. And here I would like to try and define what, for example, the exclusion for very short extracts does mean and how it should be intended at the national level. And then to conclude, looking into exceptions and limitations, and indeed identifying first and foremost which exception potentially applies, and secondly, how far that exception can go. So the picture is very complex. I hope that I will provide a presentation that is useful to those in attendance. So let's start with the first topic, understanding the legislation that does apply. And here, as you know, the copyright system is in itself quite stratified. It consists of several directives and a couple of regulations. But that is not all, because there is also horizontal legislation that comes into the picture. And here I'm referring to the Enforcement Directive, which is valid for all the IP rights. I'm referring to the e-commerce directive first, and going forward, the Digital Services Act. And then, of course, the Data Act, the AI Act, the GDPR. So it is a very complex legislative system. And to outline all these, let me take Article 17 as a case study. You all know that this is a system that is essentially is presented as a clarification of the pre-existing legal approach, but it is more of an evolution, I would say. And this was indeed also confirmed by the Court of Justice in its decision in YouTube Siando. So it starts from the assumption that those hosting providers which qualify as online content sharing service providers, the definition of which is provided in the DSM Directive itself, do directly perform copyright relevant acts and therefore are in need of an authorization from concerned right holders. And here I would say that the apparent simplicity of all this immediately clashes with the place that Article 17 has within the copyright system. The first aspect to clarify is who an online content sharing service provider is, and indeed who falls within this definition. And the reason why this is made more complex is because of the very language of the DSM directive. And in particular, I'm referring to recital 62. You know that recitals are not positive provisions, but they serve to interpret the content of the actual articles. And recital 62 clarifies that an online content sharing service provider is someone who is in essence in competition with video and audio streaming platforms, so Netflix and Spotify. And there are some member states which, in their own national definition of online content sharing service provider, have not limited themselves to replicating the positive definition found in Article 2 of the DSM directive, but have also added this clarification from the preamble. And I would say that this already raises a number of interpretive uncertainties. For example, there are some commentators who have submitted that a service like Instagram or Facebook should not be regarded as an online content sharing service provider because of this lack of competition with the likes of Netflix and Spotify. And the same will go, for example, for dating apps, platforms like OnlyFans, and so on. So the first point of complexity is what an online content sharing service provider is and who falls within the definition. Because if it does, then of course Article 17 does apply. But if it does not, then the relevant regime will be that of Article 3 of the InfoSoc directive. And what does that lead to? It leads us to a situation in which the platform attendee might not be directly performing copyright restricted acts, because in such a case, the standard to apply will be that set forth by the Court of Justice in the YouTube Siando decision. And in particular, there the Court of Justice clarified that yes, a platform operator might be directly communicating to the public, but in order to make such an assessment, a number of criteria need to be taken into account, including whether the platform operator has knowledge that there is unlawful content on the platform, what the terms of service do say, whether there are content filtering tools that credibly counter the making available of infringing content, whether there is the promotion of unlawful content on the side of the platform, what their business model is, and also how much unlawful content is present therein. And if one reads the judgment, the Court of Justice is of course not a court on the merits, but there it went as far as indicating to the national court how the relevant case should be decided. And it hinted indeed at the fact that YouTube, under these factors, will not be communicating to the public under the InfoSoc directive, while uploaded a cyber locker where the vast majority of content appear to be unlawful will be instead deemed liable. So essentially, the result of all this is the following. First, for those platforms that are not online content sharing service providers, the relevant liability regime will remain that of the InfoSoc directive, and this might lead to results in which no liability or responsibility for user-uploaded content would subsist. Second point, which is of practical relevance to those platforms that instead qualify as online content sharing service providers, it appears from this judgment that first, Article 17 is not just a codification of the pre-existing regime, it is an evolution, okay, a consistent evolution, but not a simple codification. And the second result, closely connected to this, is that there might not be any retroactive application of Article 17. So it is not possible for a right holder to bring a claim for content that was present on YouTube starting 2015, and so claim that Article 17 would apply retroactively since the date of the upload. These claims now appear precluded. So that is the first complexity, understanding which copyright-specific legislation applies. Is it the DSM directive or is it the InfoSoc directive? And the result of this determination is very substantial. And this, of course, is also valid for those countries like the UK, which, despite their departure from the European Union, remain closely connected to the EU, at least for the time being. No legislative changes occurred. So to determine liability under UK law of a platform, the relevant case law of the Court of Justice on the InfoSoc directive will need to be applied. The second point of complexity, as if things were not already complex enough, is indeed the interplay that was outlined earlier on by Anke between Article 17 and the DSA. So the relationship between these two instruments is that of lex specialis to lex generalis. And that means that what is specifically regulated in Article 17 will take precedence over the general law found in the DSA, but when Article 17 doesn't say anything, the DSA will apply instead. In turn, this has very practical relevance in terms of latitude of member states' transposition. For example, member states might have thought that there was some room to fine-tune the content of Article 17. Seems to me that right now, given the complexity of the EU legislative framework, the less member states do, the safer it gets. So let's see some of the interplay between Article 17 and DSA. An instance in which Article 17 will take precedence of the DSA is when it comes to indeed monitoring obligations, and in particular stay down obligations. Article 17, paragraph 4, letter C, imposes upon online content sharing service providers to keep the content that has been notified by right holders out of the platform. There is no such stay down obligation in the DSA, so this is a clear instance in which Article 17 will apply, it being the lex specialis regime. But then there are situations in which Article 17 does not offer much guidance, and in turn the DSA will apply. One such example, notice and action. As you know, the DSA harmonizes the notice and action regime. Article 17.4b is about notices submitted by right holders. And of course, these notices will need to look as the DSA requires them to look. Another aspect, the trusted flaggers regime. It was expected when the DSM directive was negotiated that at least in certain sectors, Article 17 could only work through a system of trusted flaggers. This system, which arose in practice out of agreements between right holders and platforms, has now been institutionalized by the DSA. So it will apply most likely in the shape that the DSA has indeed designed. Safe harbor availability. Article 17 excludes the availability of the safe harbor for activities that fall within the scope of application of that provision. But for anything else, the safe harbor is not precluded in principle. So the conditions and requirements for this safe harbor to apply will be those of the DSA, which in essence crystallizes the case law of the Court of Justice on this point. Then when it comes to transparency obligations of platforms, this is an obligation imposed by the DSA, but of course, when it comes to revealing how notices are processed, how many are processed through automated means, here we have a clear connection with the requirements of Article 17 and in particular the safeguards that the Court of Justice of the European Union identified in the Polish challenge to Article 17. So there the CJU said that automated content recognition technologies can be used, but they need to comply with a number of requirements. And knowing whether that indeed has been done could be possible through the transparency obligations that the DSA does impose. So to sum up, I've taken Article 17 as a case study that in itself gives rise to immense complexity, but this could be done for any other provisions of the copyright framework. It will be indeed key to understand who falls within each and every provision and to what extent. Then the second level of complexity is indeed to understand what object is at end. And here I would like to point out that works of applied art still raise several questions. As you know, these have always struggled to find a place within the copyright system out of belief that the natural, if one can call it like that, form of IP protection for these functional objects with aesthetic appeal will be indeed the design rights. So apart from countries like France, which has always had a unity of the art approach, in the other member states of the European Union, the common sense has been to say, okay, copyright protection can be available, provided that there is something extra, something beyond originality. And this has translated into requirements of artistic value, aesthetic effect, etc., etc. Now, it has become clear for over, I would say, 10 years since the decision in 2009 in InfoPac that this approach may no longer be appropriate. Indeed, the Court of Justice has taken it on itself to push the boundaries of harmonization well beyond the intention of legislature. And despite the wording of the design directive, on which I will return in a moment, which clearly leaves to the individual member states to determine the conditions for copyright protection of works of applied art, it has become consistently clear that this freedom does not exist. There is a EU-mandated standard of originality and a non-discrimination approach that the Court of Justice has entailed. Indeed, in the most recent decisions on works of applied art, Cofemel and Brompton Bicycle, the CJU essentially confirmed that you can no longer require artistic value, aesthetic effect. The alpha and omega of copyright protection is originality. There must be a work, and that work is original. That is sufficient and necessary. So, why then are we still discussing these issues? Because here we have an additional complexity to the one that I have detailed a few moments ago. Earlier on, I spoke about the interplay between different pieces of legislation. To this, it should be added that there is also another interplay that one needs to consider, and it is that between legislation and case law of the Court of Justice. So it is becoming really a nightmare. Indeed, the CJU has often acted out of any statutory basis, out of internal market building concerns, but indeed, a lot that has happened in the copyright field has been through the case law of the Court of Justice. And that's why today, nearly 15 years after the ruling in InfoPac, we have national legislatures that speak of an artistic value requirement, national courts that openly rebel to the CJU case law by applying national statutes and refusing to follow the CJU approach. And now we have a new referral to the Court of Justice asking indeed how to assess originality, specifically with regard to the table that you see on the slide. Does the intention of the author matter? Is the creative process of relevance, or should we only look at the work? And does it matter if there is a departure from what is customary in a certain field? So all these questions still are in need of an answer, and once again it will be the Court of Justice to answer them. What is interesting in all this is the following, that if we look at the ongoing reform of the design system, the Commission's rewording of what is still Article 17 of the Design Directive is going in the direction of being fully aware that this discretion that the old design directive left to member states is no longer there. Indeed, the rewarding of the provision of the design directive, which will be renumbered, is in the sense that designs should be protected under the copyright laws of individual member states in accordance with the EU understanding of originality. So here we have a clear situation in which the EU Commission and likely going forward the EU legislature, so the Parliament and the Council, just take account of what has happened. There is no longer this discretion that the legislator had left to member states. And we have examples in this sense also in the DSM directive. Article 14, for example, that is the provision concerning protection of reproductions of works of visual art in the public domain, codifies this case law of the Court of Justice on originality by stating that protection will be only possible if the reproduction attained is original on its own right, in the sense of being the author's own intellectual creation. So what does all this tell us? That there is the complexity of these patchwork of legislations, and on top of this case law of the Court of Justice, which I would say would be a gross mischaracterization to call an interpretation of the law, because it has been nothing of this sort. The Court of Justice has been materially a co-legislator in the copyright field. And of course, also this leads to the extent of right holders' control. Here, determining which legislation does apply also determines how far the right holders can control the use of their works. I will not discuss at length the Tom Cabinet case because it was decided a while ago, 2019, and there, I think correctly, the Court of Justice excluded the existence of digital exhaustion. But it is not that decision that changed anything. It is the decision of the Court of Justice nearly 10 years earlier in Usoft, which had created an uncertainty that should have not been there. And then, of course, determining also what right is at issue gives rise to a number of questions. Let's take the right of reproduction. It is the simplest and the most classical of all copyright's exclusive rights. Indeed, if we take the word copyright, it is the right to control the making and distribution of copies of works. And yet, what is and what falls within reproduction gives rise to several questions. So, let's take the divide between copyright works and other type of subject matter, specifically objects protected by related rights. So, insofar as the former are concerned, we know from InfoPack that there is a reproduction in part when what has been reproduced is a protectable element of a work, and more specifically, it is an original part. But what is the logic for related rights? Can we apply an originality understanding? And here we have guidance from the Court of Justice in the Pelham case. So far, that is the only case decided by the Court of Justice clarifying what indeed the rationale of protection of related rights insofar as reproduction is concerned. This is a picture that nothing has to do with the Pelham case. It is Harry Styles with one of his producers, but essentially in Pelham, the opinion of the Advocate General highlights the rationale of protection of related rights and noted that what is protected is not the originality of the related right holder, but rather the investment made by that right holder. So in the case of a music producer, as it was the case of Pelham, what is safeguarded is their investment in the production of the phonogram. So in particular, the Advocate General opinion suggests that the right of reproduction in this case protects investment. And in turn, that means that there is a reproduction in part of a subject matter protected by a related right when that part is the reflection of one's own investment. That is the decision. Now, let's translate that to the press publisher's right. Indeed, it was outlined the complexities also insofar as the national transpositions are concerned. There are member states that have really adopted creative approaches in transposing these related rights. But as you know, Article 15 of the DSM directive does exclude from the scope of protection individual words and very short extracts. This is a legacy of the old German related right for press publishers, a history of failure on all levels. But despite this, it has been a language reiterated at the EU level. So now we have this exclusion for very short extracts. An exclusion that has given rise to a lot of discussions, attempts at the national level to provide a definition of what very short does mean. But where do we stand? Are these national definitions correct? I would argue probably not. Indeed, as also the European Commission outlined in its guidance to Article 17, when something does not allow member states to define the meaning thereof, we are speaking about autonomous concepts of EU law, which in turn must be interpreted and applied uniformly across the European Union. So what does all this tell us? That those member states that define what a very short extract is probably will find themselves in trouble. So how can we understand what very short does actually mean? I think that here this investment rationale that the Court of Justice presented in Pelham might be a valuable guidance. So an extract will be very short when it does not sufficiently display the investment made by the right holder. Two examples come to my mind. If what is reproduced from a press publication is a pure factual account, so a short account of an event happening, there I would say there is no investment because a mere factual account does not reflect the investment made by the press publisher. Vice versa, if what is reproduced is the content of an interview with witnesses at a scene, impressions or commentaries from some involved in this news story, there I would say there is an investment logic, because indeed the journalists sent by the press publishers to collect something that goes above the fact is something worth protecting, an expression of investment. Similarly, an headline is something that sometimes can be very creative. So I would say even protectable by copyright, but for sure having a catchy headline is what convinces someone to read a newspaper, to read an article. So the reproduction of an headline might be even reflection of investment. In all this, I would say that what emerges from this copyright system is something in which understanding what object are we speaking of is an additional source of complexity, but a necessary complexity in light of developments occurred over the past few years. And then coming to the final block, what exceptions and limitations applies and how, as you know, in the European Union, we have a closed catalog of exceptions and limitations. The CJEU has expressly clarified that it is not possible to open up that catalog at the national level. So what an operator is required to do is indeed to identify a potentially applicable exception and limitation and determine if the conditions thereof are satisfied. On top of all this, I would say there is also the constraints and the boundaries that the three-step test offer to any available exception limitation. And here what we've seen over the past few years has been also a change of understanding, which will be necessarily have to be borne in mind also in practice. So we have moved from the idea that exceptions are in need of a strict interpretation because they are derogations from the protection of copyright to instead the idea that they are expression of other fundamental rights and freedoms, including freedom of expression, and therefore they need to be fairly balanced with copyright. They are no longer minor or things that are less deserving of consideration. The CJU clearly tells us that exceptions and limitations are something of equal dignity than copyright. And in this sense, we've seen from the most recent case law that the Court of Justice has often referred to the importance of this fair balance, the need to consider the EU Charter. And if you look at the blocks of cases between 2009 and 2022, I think it is quite clear that, for example, the EU Charter was not referred at all in the first block of cases between 2009 and 2013, but then it has emerged quite visibly in the most recent cases. So there has been a change that, of course, also informs the interpretation and application of relevant provisions. In all these, finding the exception does apply is by no means an easy exercise. And once again, this 20-plus-year-old still running legal saga in Pelham is testimony to all this. Now, as you will have seen, a new referral has been made to the Court of Justice, asking this time not whether a sample is a quotation, but whether a sample can be pastiche. So this shows also the difficulties of identifying the relevant exception to cover the doing of a certain activity. And last but not least, of course, the rise of generative AI, which has been already discussed at some length, gives rise to new questions, and in particular to what extent an AI system can be trained on third-party protected content. So we've seen the sudden rise of ChatGPT, Midjourney producing excellent-looking content, and of course, with all these, the rise of litigation as well, which will be also discussed at greater length this afternoon. The most recent one is Scarlett Johansson suing indeed over the ripping off of her likeness, but this is just a snapshot of litigation that will indeed continue being brought over the next few months and years. And in all these, it will be indeed the key to determine how far Article 4 of the DSM directive goes. And in particular, what will be key is indeed this reservation possibility that has been already discussed, the one in Article 3, to what extent and how right holders can opt out of the application of the exception, and in what situations these reservations can be considered effective and enforceable. On top of all this, I would say that it might not be enough to determine the lawfulness of these activities just to look at the conditions for a certain exception, because also the text determining provisions of the DSM directive require compliance with the three-step test. So I will not say that any kind of mining process finalized on the training of AI will be excused insofar as right holders have not opted out. I don't think that that is absolutely the case. Indeed, by complying with the three-step test, even where no reservation has been made, there are situations which clearly will not fall within the scope of application of the provision. I'm thinking, for example, a case in which a singer-songwriter has not opted out of Article 4, and then an AI system is trained entirely on their repertoire. Here, I will not say that Article 4 is applicable, even though the right holder has not exercised the faculty under paragraph 3. And indeed, there is also the need to consider the application of the GDPR, which is expressly made safe by the DSM Directive 2. In all these, as you know, the AI Act is approaching the finish line. The Spanish presidency is pushing quite substantially for a wrapping up of the process, and the latest is, of course, not only transparency obligations for AI system, but the need to consider the reservation carried out by right holders in light of Article 4. So this will likely be part of the final text of the AI Act. So coming to a conclusion, the copyright framework over the past several years has become increasingly complex on all levels, not only to understand which legislation does apply, but also figuring out what object of protection we are speaking of, and in turn, which right is attended, because we have different rights of reproduction, communication to the public, distribution, and also the exceptions and limitations have been reframed and recast by the Court of Justice in a charter framework. So going back to the beginning, these internal and external limitations that A.G. Spooner was referring to, yes, they were considered a big deal when he highlighted them, and for sure they are, but there are several internal and external overlaps, not limitations, overlaps in the copyright system, which make it increasingly complex to navigate. And on top of all this, the CJU itself has put itself in a position of competition or complementing the work of EU legislator. And with that, I conclude, and thank you for your attention.